Hello everyone, I'm Mustafa and I'm Associate Professor at UFA University of Science and Technology, Institute of Law, and also Legal Counsel. Welcome to my channel, Mustafa Contract Law Hub, where I'm planning to tell you about everything you need to know regarding contract law, from basics to advanced concepts. Whether you are a student or a professional or just someone interested in understanding how contracts work, you've come to the right place. So, let's embark on this journey together and explore the fascinating world of contract law. Again, I'm here to speak about another important and significant concept under contract law: intention. I told you about the requirements of creating new contract. One of these requirements was intention. An agreement, an intention, capacity, certainty, and also consideration. So today I would like to speak about the intention and also the role of intention in creating new legal relations. When we think about the two parties that they are trying to make an agreement and just they have simple words or informal words, these informal words in fact can be considered as agreements that we need under contract because of their intention. This intention and role of intention is so important because if such a claim that, for example, parties try to say this is contract and we had contract, if we raise before the court and court analyzes the situation, courts see this is not contract because at the very beginning these two parties haven't had any intention to make legally binding contracts. So this intention is so important, and courts as well think about the objectivity relations and analyze the situation objectively. And as far as we think about this intention and the role of this intention to create new legal relations, so we must divide the contracts in two categories. In fact, the categories that based on the intention bring some legal relations, and on the other hand, the categories or contracts that they are informal and they are not legally binding. That I divided them here as social agreements, domestic or social agreements, and on the other hand, commercial agreements or commercial transactions. Social and domestic agreements is so easy to get because when we speak about these contracts, it means these contracts are informal and more the people trying to make an agreement without any legally binding nature. For example, the contracts between wife and husband or between parents and children. They try to make some agreement, but they don't have any intention to make it legally binding, to be bound by the law under this agreement. For example, some parents that they tell their children that if you pass your final exams, we buy for you new bicycle. So it's just for encouraging the children to make their final exam better or pass them in best way. But it's not legally binding unless there is obvious evidence that they had such a mindset that they wanted to be in legally binding nature. They wanted to be bound by this contract. But in general, such domestic contracts are not in this way. And also, if we think about the other relations, for example, between their friends or the people that are not relatives. Still we have such contracts. Like for example, I invite you for a party, or I invite you for my birthday, and or for moving my house. I ask you to help me, and first you told me, okay, I help you, or I come to your party, but at the end or 1 week later, over time, you change your mind. Here I can't force you in love because only you wanted to help me, and or you want to participate, but you couldn't. So it's not legally binding, and we are not legally bound by this agreement. It's only informal agreements. The other agreements that I told you, commercial transactions or contracts, that when we speak about the commercial transactions, in fact, they are formal, and there is such a presumption that the parties to this agreement try to make legally binding contracts, try to be bound by law. So, in general, this is rule that commercial transactions are legally binding. But maybe sometimes we see case by case, the situation can be analyzed that the intention and the words and the context of the contract is not in the way to consider them as legally binding contracts, or the parties be bound by this nature and by this contract. So here I want to tell you about 3 situations that we see that commercial contracts are not legally binding contracts, that you can see here: mere puffs, honor clauses, and agreements subject to contracts. That's these 3 situations, or these 3 concepts that I would like to tell you today are the situations that the commercial contracts maybe are not binding, but still I'm telling you, we should analyze case by case, and the courts trying to do it if such disputes raise before the court. First, mere puffs. It's easy. You saw many times promotional statements or advertisements. Sometimes you see such words. For example, I'm a car dealer and I'm telling on this advertisement that this car is the best in the world. So it's only words. It's the sale talks. It's not true. I can't say it's completely fake, but it's not true. These words are exaggerated, and we can analyze these words that they are not completely true because we know them. It's mere puffs. It's sale talks. By the way, maybe case by case we can analyze it and we can understand something on the contrary. And the other as well, here you see honor clauses, that these honor clauses, based on these words, we have some obligations or duties under the contracts that must be respected, must be done and fulfilled. So such clauses are so important for the parties, and if the parties don't do it or don't respect them, maybe the contract considered void, or maybe the parties need to pay something as remedies or some other features maybe on the contract to make up these situations. And the next one are agreements subject to contracts. How about this one? In fact, we see all the time the parties try to make negotiations, and through the negotiations they try to bring some obligations, duties, and responsibilities based on their intention, based on their need under this agreement. So, this negotiations, and these preliminary negotiations only are the situation or the phase that the parties try to prepare the way to make final contract. So these are not final, these are not formal contract that the parties, for example, claim that these wars or these negotiations are legally binding or be bound by them. No, these are just negotiations, and the way to make the situation prepare and ready for final contract. And ambiguity. Sometimes we see some contracts that they are ambiguous, and the courts need to interpret the circumstances, the aspects around the contract or the negotiations and so on. If we see such ambiguities, we see many times, as I saw, the courts try to interpret situation to get to this point that we have a legally binding contract. And many times we see this interpretation that court did based on this mindset that maybe at the end we need to see this is a legally binding contract. But by the way, I'm trying to tell you that it's not completely true as I'm telling, because maybe case by case we can see another way, and we can see some situation on the contrary, and that contracts are not legally binding. At the end, the last slide for today and the last information, as you see, again, if you look at this figure, when we speak about the intention to make new legal relations, so we must divide these contracts or agreements under two categories. First, social or domestic agreements that they are informal and the parties don't have any intention to make legal binding contract. But on the other hand, we see commercial agreements or commercial transactions that this is a presumption that parties try to make legally binding contracts based on their intention. Okay, thank you so much again for joining me today, and see you soon. Wish you the best. Bye.